I was 8 months pregnant when my boss called and said, "We're restructuring your position. Your services are no longer needed." I was on federally protected maternity leave. What she did was illegal. This is case number 002 in the Reckoning Ledger. I'm Rachel Thompson from Seattle, Washington, and this is how I turned a wrongful termination into a $400,000 settlement and got my boss fired. I'd worked at Tech Vision Solutions in Seattle for 6 years. Senior project manager, stellar performance reviews, 3 promotions. I was good at my job. When I told my boss Karen I was pregnant, her reaction was cold. "Congratulations, Rachel," she said. Her smile didn't reach her eyes. "We'll figure things out." Not, "I'm happy for you." Not, "We'll support you." Just, "We'll figure things out." That should have been my first warning. I went on FMLA leave in August. My daughter Emma was born healthy and perfect. The first 3 weeks were a beautiful blur of sleepless nights and tiny fingers. Then came the phone call that changed everything. Tuesday afternoon, 2 p.m. I was nursing Emma when my phone rang. Karen. "Rachel, hi. We need to discuss your position." My stomach dropped. "Is everything okay?" "The company is restructuring. We've had to make some difficult decisions. Your role has been eliminated. We're going to have to let you go." I felt my heart stop. "Karen, I'm on FMLA leave. You can't fire me while I'm on protected leave. This isn't about your leave, Rachel. It's a business decision. Your benefits end in 30 days. I'll email the paperwork." She hung up. I sat there holding my 3-week-old daughter and cried. The next morning I called David Hernandez, an employment attorney specializing in discrimination cases. I told him everything. "Rachel," he said, "this is textbook FMLA retaliation. The Family and Medical Leave Act protects you from termination during and after medical leave. They just handed you a federal lawsuit. What do I do? Don't sign anything they send. Forward me every email and document. Write down everything you remember about Karen's reaction when you told her you were pregnant." The termination email arrived that afternoon. Subject, position elimination, restructuring. It claimed my role was eliminated due to company restructuring. But 3 days later, I found my exact job posting on LinkedIn. Same title, same responsibilities, same salary range. They weren't eliminating my position, they were replacing me. David's team dug into Tech Vision's history. What they found was damning. I wasn't the first. In the past 4 years, 3 other women had been pushed out after pregnancy, all under Karen's management. Emily, 2020, put on a performance improvement plan 2 weeks after announcing her pregnancy. Fired 3 months later. Sarah, 2021, returned from maternity leave. Her hours were immediately cut to part-time, forcing her to quit. Monica, 2022, promised a promotion, announced pregnancy, promotion postponed indefinitely. She left after being passed over 3 times. None of them had sued. They'd taken small severances and moved on quietly. But together we had a pattern. David contacted all 3. 2 agreed to join the lawsuit. "Rachel, this isn't just wrongful termination. This is systemic pregnancy discrimination." We filed a complaint with the EEOC and started discovery. Discovery is when both sides have to share evidence, and Tech Vision's evidence destroyed them. We subpoenaed internal emails. Email number 1. 2 days after I announced my pregnancy. From Karen to HR. "We need to start documenting performance issues with Rachel. I want options by end of quarter. I had 0 documented performance issues." Email number 2 to the CFO. "Rachel's pregnancy leave is going to hurt Q4 deliverables. Can we reorganize while she's out?" Email number 3. The smoking gun. A text to another manager. "Pregnant employees are a liability. I'm not dealing with another maternity disruption." David called me after seeing the emails. "Rachel, they're going to settle. This is indefensible." Then came Karen's deposition. She contradicted herself repeatedly, got defensive, and made everything worse. Attorney: "Did you replace Rachel's position?" Karen: "No, we eliminated it." Attorney: Then explain this LinkedIn posting with identical requirements." Karen: "That's a different role." Attorney: "With the same title, salary, and reporting structure?" Karen: "I don't recall." Tech Vision requested mediation. Their opening offer, $75,000. David laughed. "We're asking a jury for $2 million. Be serious." They went to $150,000. David laid out our case. 4 victims over 4 years. Pattern and practice of discrimination. Damning emails showing intent. Karen's disastrous deposition. Federal FMLA violation. Seattle jury pool, notoriously pro-employee. A Seattle jury, David said, is going to see a new mother fired while caring for her infant. They're going to see those emails, and they're going to award significant damages. TechVision went to $250,000. I looked at David. He shook his head. $400,000. Karen is terminated immediately. Mandatory anti-discrimination training, independent HR monitor for 3 years, non-negotiable. They caucused for 90 minutes. They agreed. The settlement, $400,000 total, split among plaintiffs. My portion after legal fees, $285,000. Karen was fired for cause, and no severance. TechVision had to implement mandatory anti-discrimination training, hire an independent monitor to review HR for 3 years, revise all parental leave policies, issue a public statement acknowledging the violations. Karen tried getting another management job in Seattle Tech. Word spreads fast. She's working a non-management role at a small startup now. TechVision offered me my job back. I declined. I used the settlement to start my own project management consulting firm. I work from home, I set my own hours, I'm with Emma every day, and I only work with companies that have real parental leave policies. Emma's 2 now. She runs around laughing, completely unaware she's the reason I fought so hard. Here's what I learned. Case number 002. Lesson number 1. Document everything. 6 years of excellent reviews saved me. Keep records. Lesson number 2. Know your rights. FMLA protects you. Pregnancy discrimination is illegal. Learn the laws. Lesson number 3. Don't sign severance immediately. Companies rush you to avoid lawsuits. Talk to an attorney first. Lesson number 4. You're not alone. If it happened to you, it probably happened to others. There's honest strength in numbers. Lesson number 5. Specialist attorneys. When David's employment law expertise made all the difference, being fired while holding your newborn is traumatic. But it doesn't have to be the end. Karen thought she had all the power. But the law was on my side. And sometimes justice is expensive for the people who deserve to pay. If this case helped you, subscribe to the Reckoning Ledger. Case number 003 drops Friday. The ledger stays open, every debt gets recorded, every debt gets paid.